this week we'll be looking at affidavits, which are sworn or affirmed statements. They are the equivalent of a person providing their evidence in chief, and they're being used more and more to reduce the time and cost associated with both hearings and trials. So an affidavit is a statement of fact. It's not intended to present arguments like an outline of argument. It is merely designed to represent what the witness would have provided as evidence in chief in the witness box. When drafting an affidavit, it's important to identify what the witness would have said on the stand, and it's important that it represents their recollection of the facts and that it sounds like them. There are restrictions on what can be included. The rules of evidence that apply to trials apply equally to evidence provided by way of affidavit. So there's a section in the study guide which goes through that in detail, but in particular, you need to avoid hearsay when drafting. So for example, Jeremy told me that David saw the defendant punch the victim. So that's third hand. David is the one that observes the defendant punching the victim. David tells Jeremy, Jeremy tells the witness. In that instance, that evidence is likely to be inadmissible. Really, the prosecution would need to call David, who observed the conduct firsthand. And it's also important to avoid opinion in an affidavit as well. So a witness who is not an expert witness says, "Oh, well, when I heard the engine noise, I decided that the defendant was going at least 150 kilometers an hour. That's an expression of an opinion, and unless that person is an expert, that would also be inadmissible. Another tip is to think about reliability. If the witness observed an incident, think about the conditions. Was it daytime or nighttime? Was there street lighting if it was nighttime? How far away from the incident was the witness? Did that witness have an unobstructed view? Were they observing the scene for the whole time, or did they only come to it later? This all goes to relevance in terms of determining how valuable that information from that witness is as part of the bigger picture. Note that if all the conditions were good, so everything was perfect for observation, then you want to make that very clear. Note that if there's some weaknesses with the evidence, that's likely to come out in cross-examination anyway. So for example, in your affidavit, don't leave out the fact that it was nighttime, because the other side will cross-examine and that will come out anyway. Instead, try and counter that fact by pointing to the fact that there was good lighting. Think about asking your witness about the conditions and think about how you can counteract some of those likely cross-examination questions. Note that you can't coach the witness, but it is your job to extract all the information that you need and place it into an affidavit. In fact, it's really important to think about what you need to know as part of the full picture of the witness's evidence, because if you get that information now, you can decide whether or not to call the witness, and also it helps you reevaluate the strength of the client's case. So it's an important part of the investigative process, even if you decide not to call that witness, for example. So don't go straight into what the witness saw in the relevant moment when the incident is alleged to have occurred, for example, because you will miss out important background information, and the court needs that in order to be able to evaluate how important that evidence is for the case and how it relates to other evidence. So think about what context a person would need to be able to visualize and understand what happened. So for example, it might be important to state that the witness did not actually observe the collision between the two cars. They were in their house, they heard a loud bang, they ran outside, and then they saw the immediate aftermath. That will affect where the witness's evidence sits in the chronology of events and in the big jigsaw puzzle that the court is trying to piece together to work out what happened on the relevant day. Time for another big red warning triangle. There are ethical issues that are relevant to drafting an affidavit. The first is that you must not knowingly mislead the court under Rule 19 of the Australian Solicitors' Conduct Rules. And in fact, it goes beyond that, because if you inadvertently mislead the court but then subsequently find out that you have misled the court, then you must take all necessary steps to correct that. This means that you need to avoid half-truths in your affidavits. For example, where you make a statement which is actually true, but if the court had the context of the other half of the information, then it would paint a very different picture. You need to make sure that you don't misrepresent the position through the affidavit. Even though it is the statement of the witness, you are still involved in the process of drafting it, and therefore those ethical obligations apply to the document that you produce. Now, in terms of format, make sure that you follow the practice direction or rules of court, which vary from one tribunal or court to another, and always use paragraph numbers because the advocates might need to refer to the affidavit in the hearing. You need to make sure that the bottom has the oath and the jurat, and on a practical level, it must be sworn or affirmed before someone who is capable of taking an oath. Now, usually when you are presenting the information, it should be in a chronological order. That's because it facilitates the court in understanding where within the chronology of events this information sits. Now, the workshop this week is focused on drafting an affidavit. Note that you would be providing a first draft. That means that you can ask questions, flag areas where you need more information, and at that point in practice you would then go back to the witness for that information and then engage in a redraft. It's at that point that you would take the redraft to the witness and you would let them read through it and check that they are happy with it. You'd also ascertain whether or not they feel that it reflects the evidence that they would give and whether there was anything that was missing. Only at that point would you then let them sign it. Okay, that brings us to the end of this video for this week. I'm looking forward to seeing you in the workshop.